I first met this little girl and her family, amazing family, when she was a few months old back in 2015. So I've been pursuing this case now for nearly 11 years. And we were able to win our case in terms of proving liability. So the circumstances are that my client's mother went into hospital not feeling the baby move. She was at term. The midwife didn't look at the heart rate trace. She'd switched off the alarms and left the room. All that time, when she'd left the room, the heart rate trace was pathological. The baby was in distress. That was due to a lack of oxygen. So had the midwife done her job correctly, she would have seen that the heart rate trace was abnormal, showing the baby in distress. They would have moved to an emergency cesarean section pretty much immediately. She would have been absolutely fine. She's the same age as my middle son. He's 11 years old. And to see him running around, enjoying life, smart, compared, sadly, to my client who should be like that, but she's blind, she's can't walk, she can't talk, she's fed through a tube. She's in great difficulty. These are injuries of maximum severity. She's got an amazing smile, though, and her family absolutely love her. She comes to life in a hydrotherapy pool. She absolutely loves the water. She was well worth fighting for. We won the case on liability. We issued proceedings to take the matter further down the line to ultimately to a court hearing to work out the value and to work out the amount of damages that she was to receive. We had 2 weeks fighting those issues in London, in the High Courts in 2023. And ultimately, she was successful on pretty much every head of loss. She was awarded a lump sum figure of £6.8 million. And on top of that, periodical payments, so a yearly amount of compensation to cover the 24-hour-day care that she needs. And she will receive that for every day that she's alive. She'll get that until she passes away. And that's index linked to the cost of care as well, so it can go up. And that was around £400,000 per annum that she receives for the 24 hours a day care. 2 carers at all times for 24 hours, which is a unusual case. And we were very fortunate that the judge agreed with us that was the need here. And then after the hearing, we had to lose on lost years because we claimed it. And in the schedule of loss, we asked for about £830,000 for the average earnings up to retirement age, plus pension loss up to the date of expected death, but for the negligence, discounted by 50%. And of course, we had to lose on that point because of this Court of Appeal decision that took place in 1981, which is in the case of Croke and Wiseman. We'd always felt strongly that was terrible law. We felt that was ripe for change. But it's rare that one gets the opportunity to make that change. We got that opportunity because we had gone to a trial. Ours was the first case involving cerebral palsy that had gone to trial on the issue of what damages should be awarded for 6 years. So these opportunities don't come up very often. So we were fortunate. It was hard work, so I say fortunate advisedly, but we were fortunate that opportunity arose, because we then could appeal that terrible old law. So we made an application to the trial judge. He allowed us to make a leapfrog appeal over the Court of Appeal to the highest court in the country, which is the Supreme Court. Couldn't go to this Court of Appeal because it was a previous Court of Appeal decision in 1981. So we had to leapfrog and create another precedent over and above that. So that's what we did. Then we prepared for a hearing, an intense 2-day hearing, in February 2025. And then we've been on tenterhooks ever since, waiting for that result. And finally, after a year of deliberation, the Law Lords have provided their judgment. It was very pleasing that we were successful. The Law Lords were divided, but we did win on a 4-1 basis. There was one Law Lord who dissented, but the other 4 agreed with us that really it was unconscionable for children to be denied lost years damages when adults are able to claim them. When I discussed this with my client's mother, should we take this step? We didn't have to appeal against this decision. It's a risky and courageous step. Clearly, it will benefit my client, who is now aged 11 with these terrible injuries. But really, the wider focus for my client's mother was actually on other people, other children. She knows plenty of them who have suffered similar injuries. And I think that as a wider impact, certainly this is my view as well, that that she is so pleased that this will now directly benefit many children who are in the same position as her daughter. I think that it will have a big impact on children who've suffered, especially injuries of maximum severity, just like my clients. It will have a wider impact as well. Children now can claim in lost years cases. Classically, that could be a cancer case as well. It may cost more to settle cases, but really the focus should be on patient safety. I would be happy if I woke up one morning and no children were being injured when they were at birth. I would be happy to wake up one morning and for there to be no more birth injuries or brain injuries involving children. I'd find another job. I could do something else. But until that happens, then I'm happy to fight for people in that position. And when people talk about the cost, well, the human cost is, to my mind, far greater. You should not expect to go to hospital and suffer those kind of injuries. Patient safety should be the focus.